Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. According to the calendar, time is marching on very quickly with respect to Voir Dire, which is scheduled to occur on July 30th, and that is the formal process of jury selection in anticipation of the presentation of the case in chief, the guilt phase of these proceedings, which is scheduled to occur August 11th, 2025. And even before those two dates, on a date that is redacted, the prospective members of the jury, the citizens from Ada County who receive notices to potentially serve in this case, will need to report to the Ada County courthouse to complete jury questionnaires. Again, those dates are unknown when the jury questionnaires will be administered and completed. Today is May 29th, exactly 10 days since the defense served and filed their motion to continue the trial. And as of today, in looking at the case summary page maintained by the clerk of court, there is no notation indicating that the state has filed a response to the motion to continue as of yet, and there has been an update to the docket itself with a few new filings. None of them are a response to the motion to continue. In my opinion, I had anticipated by at least now that the state would have filed a response because of all of the things that must happen first before the court can render a ruling as to whether to grant or to deny the defense's motion to continue the trial date to a later time frame. First, the motion has been filed. That is an application for a court order. There are two other items that are filed before the briefings on the motion to continue are closed, similar to briefings in other matters, such as the motions to strike the DP, such as the motions to suppress evidence, and such as the motions in limine. All of those followed the following sequence: the filing of the motion, the filing of the response, then the filing of the reply. And what the reply is that is the originating party. Here it would be the defense. They filed the original motion. They get to file a reply replying to the response. At that point, briefings are closed. But that's not all that needs to happen. Then there would need to be a hearing date negotiated and set when the court and both sides are available. And then that hearing would need to happen where both sides would get up and argue their respective positions, either for continuance or against continuance. And then and only then would the court be in a position to make a ruling. There have been times when Judge Hippler has made proclamations from the bench. He has announced what his ruling would be in prior hearings, such as on certain of the in limine motions. He gave his ruling the day of the hearing, which was April 9th, 2025. Other times he takes both sides' position under advisement, meaning he will consider both sides' positions regarding the matter before him, and then he issues a written ruling. So with all of the above in consideration, I had anticipated, as I've said, that there would be a response filed by now to this very important motion. It's not to say that there's not time still for it to be filed. There is. And if it is filed tomorrow, day 11, we will let you know. Until next time, this is Kathy. Thank you for joining us today.